estamos. Si quieres sentarte todavía, yo me siento.
This is for you. It's just something to remember as five.
I can sit here?
Yes, 1, 2, 3.
¿Dónde me hago? Aquí en el último acá.
Y podemos poner las cosas en. We can play the everything.
Oh, yes.
Just let me take out my computer and.
She's not here. Alexa? Yes. Is Clara here? Clara? Oh, there she is. Okay, great. Perfect. Here it is. Yeah.
Oscar, si vuelvo técnico solo para que sepa. Porque ahorita la. Sí, porque la más fácil ustedes que están aquí y entonces ustedes pueden estar acá. Pero si la quieres cambiar, habla con.
Pero está muy
A mí me gusta.
That's not going to work because I think mathematics. Did it detect anything? Did it do a little noise? Yeah. I mean, look, it's try like test. When I'm going to see. El mismo programa no Classic Checking next time es el tuyo, ¿no? Sí. Bueno, sí, tendrás que hacer Bueno, les conviene hacerlo.
Sí.
¿De dónde me siento? Me voy a sentar acá.
si les permiten. We begin first by acknowledging the land when we are from ILADA, the Indigenous Law Association, will.
Okay, hi everyone. As Professor Hugo said, my name is Clara Chang. I'm a 2L law student at the faculty here, and I'm a settler on these lands. I'm also, as you mentioned, a member of the Indigenous Law Association, and I've been very graciously invited to deliver our land acknowledgement today. So this land acknowledgement serves to remind everyone that McGill University is located on ancestral, unceded, and indigenous lands. The Ganetgahaga of the Haudenosaunee, Anishinaabe, and many other nations have long been recognized as the custodians of these lands and waters. Where we are today, so Chukchoge, or also known as Montreal, is historically known as a gathering place for many First Nations, and is now home to a diverse population of Indigenous and other peoples. So let us all acknowledge and respect the Indigenous peoples' continued connections with the territory that is now known as Canada. ILADA and this event's organizers honor, recognize, and respect these nations as the traditional stewards of the lands and waters on which we now live and gather.
Thank you very much, Clara. And as she mentioned, my name is René Bravo. I should have started perhaps with that. I'm a professor in the Faculty of Law and autrefois director of the Center for Human Rights and Legal Pluralism. And it's my pleasure to welcome you today and to situate this talk as part of one of the main lecture series run by the Center for Human Rights on a regular basis, this being the John Humphrey Lecture. John Humphrey was a professor at the Faculty of Law here at McGill, and we recall most of all his central contribution to the Universal Declaration of Human Rights, of which he authored the very first draft on the basis of the UN committee working under the direction of Eleanor Roosevelt to produce what became a central document for international human rights law. And if you're ever curious, McGill has the archives of the sequential drafts of the declaration with John Humphrey's handwritten annotations. A very interesting document to consider. In 1988, to celebrate the 40th anniversary of the Universal Declaration adopted by the UN General Assembly in 1948, the Faculty of Law at McGill decided to create the Humphrey Lecture series. And the first speaker was John Humphrey himself. And he's been followed over the years by many people, including Javier Perez de Cuellar, the former United Nations Secretary General, Sally Ngumeri, a well-known legal anthropologist, Abdoulaye Al-Naim, one of the luminaries in the conversation about cultural diversity and human rights, John Burroughs, and many others. And we are very lucky today to add to this illustrious list with 3 justices from the Special Jurisdiction for Peace, or the JEP, in Colombia, established pursuant to the 2016 peace agreement between the FARC and the government of Colombia, and which has been at work since then, or not quite since then, but since a short while after that, to attempt to steer Colombia towards a more peaceful and less violent transition to justice and to peace, which has proven, as we will hear, enormously difficult for a range of reasons that converge in making the challenge of transitional justice enormously challenging in Colombia. So we have, as I mentioned, three justices. Justice Oscar Parra-Vera, who is a fellow graduate from Oxford University from the Center for Criminology and Criminal Justice, is a lecturer at the National University of Colombia, worked for the Inter-American Court of Human Rights and as well at the Inter-American Commission on Human Rights, and he's contributed also to the UN Committee on Enforced Disappearances. Then Justice Xiomara Balanta-Moreno, Dr. Balanta-Moreno has a PhD in law from Rey Juan Carlos University in Spain, a master's from Notre Dame University in the United States, and is a graduate of Universidad Andina Simón Bolívar in Ecuador. She serves in the Chamber for Amnesty or Pardon of the JEP and previously was the Vice President. Finally, Justice Alexandra Sandoval-Mantilla, also a justice at the Chamber for Amnesty or Pardon of the JEP, was previously a lawyer for an NGO, Women's Link Worldwide, worked for the Conseil d'Etat of the Colombian state, and was also a lawyer at the Inter-American Court of Human Rights in San Jose in Costa Rica. She's a graduate of Los Andes University in Bogota, and has also a graduate degree from Utrecht University in the Netherlands. So I leave you in their hands for what I'm sure will be an extremely rich but also an extremely important conversation. Creo que nosotros en Canadá tenemos mucho que aprender de la experiencia colombiana y eso es oportunidad única de oírlo directamente desde Colombia. Por favor.
Thank you so much.
Very briefly, I'll be chairing the panel. I'm Frederick Megre. I'm the co-director of the Center for Human Rights and Legal Pluralism. We're actually delighted to have the justices with us tonight, and I want to acknowledge Yuri Romana Rivas's role in triggering this event, part of a very strong contingent of doctoral students at the faculty from Colombia. And we had, wanted to do something of the kind for a while, but I think without his creativity and initiative, it wouldn't have happened. So I wanted to thank him for that initiative. I also wanted to say that where I think in some ways the situation in Colombia is not as known as it ought to be in Canada. There's been a lot of interest in transitional justice, certainly among my students, but I think we're long overdue to have a sort of thorough presentation on what's been happening. I think it's really been the cutting edge of a lot of transitional justice efforts. It's raised, really fascinating dilemmas, and that's why we particularly look forward to this evening's conversation. The justices have very kindly agreed to each give a 15-minute presentation on different aspects of the transitional justice process in Colombia, and then we'll open the floor for questions. And so Oscar Parra-Vera has agreed to give us a kind of introductory overview of the special jurisdiction for peace, and specifically something that is being closely associated with the prosecution of macro cases. Thank you very much.
Thank you for having me here. We organized something with the presentation. Well, in this, okay, firstly, I would like to say thanks to Professor Megret and to Julie Romagna for this opportunity to be here. And thank you for the Center for this opportunity to share some of these ideas about the work of the Special Jurisdiction for Peace in Colombia. I would like to begin with this picture about a hearing last year when we can see FARC leaders in Colombia acknowledge full responsibility regarding kidnappings in the context of the armed conflict in Colombia. And this is so important because it's the first time after a peace deal that a guerrilla movement acknowledged responsibility for crimes against humanity after a peace process. And this is a very important outcome of the special jurisdiction last year. And one question arises is how did we get to this point after 5 years of work? And as an introduction, I would like to say that we have in Colombia more than 50 years of armed conflict, and it's an ongoing armed conflict that continues until now. We have the Revolutionary Armed Forces of Colombia, the FARC, and the National Liberation Army, ELN, currently in a peace negotiation with the current government in Colombia. This is the two main guerrilla groups and obviously paramilitary groups around the armed conflict in the past decades. And as a starting point, we have to take into account a lot of victims in the context of this armed conflict. More than 100,000 of forced disappearances in Colombia, more than 2,000 of victims of sexual violence, more than 18,000 of victims of recruitment of children, and more than 8 million of people in the context of forced disappearances, forced displacement. And the victims of kidnapping arise to more than 27,000 of victims. And extrajudicial killings, more than 6,000. And as a starting points for the work of the special jurisdiction, we have to put these questions to analyze this kind of massive and systematic violence in the context of the armed conflict. In the context of the peace accords in 2016, one question defines a lot of mechanisms inside the special jurisdiction. How to combine the effort to find justice for victims with the effort of achieving political settlement for an armed conflict. This is a key question to understand the design of the special jurisdiction for peace. Another starting point is the impossibility of amnesties regarding international crimes. In the past, after a peace accord, there is a lot of amnesties during the story of peace accords, but after the Rome Statute of the International Criminal Court, it's not possible to grant this kind of amnesties for international crimes. But at the same time, we have to think in the new role for the amnesty in the context of political crimes, in the context of a negotiation for peace. And these ideas explained the special jurisdiction for peace as a new jurisdiction, different to the ordinary jurisdiction in Colombia. It's not the ordinary system in the context of a system that is, in the context of the negotiation, an enemy of one of the parts, the FARC guerrilla. And the main objective of the special jurisdiction is the legal closure for the armed conflict. And one point in the context of the agreement was the necessity to judge all the parties, all the armed parties in the context of the armed conflict. And because of that, the special jurisdiction is judging not only the FARC, but also the state and also the third parties also the businessmen and business enterprises, the enterprises involved in human rights violations. And another starting point relevant for this discussion is the creation of a comprehensive system for truth, justice, and reparation, and guarantees of non-repetition. It is important to take into account that we have in Colombia more than 20 years of discussions on transitional justice. And the balance is the necessity to use judicial mechanisms as the special jurisdiction, and also extrajudicial mechanisms like the Truth Commission or a special unit for the for looking the people disappeared during the conflict. We can see here the structure of the special jurisdiction. We have 3 justice chambers, and we have a chamber for acknowledgement of truth, responsibility, and determination of facts and conducts. And this is the chamber in which I'm working now. The chamber for determination of legal situations, with a specific focus in the work with the armed forces, and a chamber for amnesty and pardon. And also we have a tribunal for peace. We can say that the justice chambers in some way is a kind of pre-trial chambers for a trial before the tribunal for peace, we have a section of first instance in cases of lack of acknowledgement, a section of first instance in cases of in cases of acknowledgement, and we can see 2 kind of avenues in this structure, and a path for people who are recognizing truth and committed to reparation, and another path for people who is disputing or who is in who will develop an adversarial path in the context of the administration of justice, and obviously an appeals section in this kind of structure. We have a specific prosecutor in the context of this structure for people who are not committed to recognize the full truth and the possibility to redress. One of the most important chambers is the Chamber for Amnesty and Pardon, and this chamber grants conditional amnesties to former members of the FARC and their collaborators with regard to less serious crimes, the not international crimes. And also this chamber grants conditional interim release to former members of the FARC, in particular cases not related to genocide, crimes against humanity, or war crimes. But I would like to focus in these 10 minutes in the work of the Chamber of Acknowledgement of Responsibility. And I will explain our work in macrocriminality and systemic crimes. The starting point is a new approach to prosecuting macrocriminality. And a first step in this new approach is to overcoming the case-by-case individual approach and proposing the prosecution of systemic crimes, macrocriminal patterns, and criminal plans in the context of the several examples of apparatus related to this kind of violence. And also the idea of the necessity of a strategy of prioritization by the special jurisdiction. It means that we cannot work in an investigation scheme on demand. We have to accumulate a lot of facts in order to create a strategy to prosecution this kind of macrocriminality. And also we have to focus in unveiling the main and highest criminal responsibilities. One example in a macro case that I will explain later, the majority of the ordinary justice prosecute only soldiers in a specific macro case, but we have to focus in the top officials, the generals, the colonels, and the special high ranks in the chain of command of the army, for example. Because of that, we have 11 macro cases in the first 5 years of work of the special jurisdiction. And let me see one example of these macro cases. Case number 1 is related to kidnappings in Colombia. War crime of hostage taking and crimes against humanity of severe deprivation of personal liberty and others kind of international crimes committed by former FARC rebel group. It's a macro case because we can find almost 20 years of kidnappings in Colombia, with more than 20,000 of kidnappings, 9,000 of members of FARC involved in this mega case, and the first indictment that we prepared 2 years ago was against 8 of the leaders of the FARC in the context of this case. But we have also more than 3,000 of victims participating in this proceeding related to kidnappings. We identified 3 policies to analyze more than 20,000 of kidnappings. The policy of financial gain for the FARC. Second, the forcing humanitarian exchanges for the FARC. And 3, preserving territorial control, punishing and intimidating using the kidnappings against the civil population in several zones of Colombia. And another example of macro case is macro case number 3 on false positives. It's like a extrajudicial killings in Colombia. And we have dealt in this case with war crimes and crimes against humanity, the crimes against humanity of murder and enforced disappearance. In a specific period of time between 2002 and 2008, 6 years of these extrajudicial killings, and we are prosecuting more than 6,000 of extrajudicial killings, and around 3,000 members of the army involved in these 6,000 extrajudicial killings. Previously, the ordinary proceedings organized some kind of justice for these more than 6,000 of extrajudicial killings, but with a special focus in the low ranks of the chain of command. But in this context, we received more than 50 reports from the victims. We have more than 2,000 of victims recognized in order to participate in the proceedings. More than 700 voluntary statements these are some kind of cross-examination of military personnel during these 5 years. 6 public hearings with observation of the victims to these kind of interrogatories, cross-examinations. And we began from bottom to top, and we began the cross-examination of more than 20 generals involved in this case. And I would like to highlight the 4 first indictments in this particular macro case. We began with an analysis of a specific policy behind these 6,000 extrajudicial killings, a policy of it's kind of a policy in which the body of the enemy killed in action was the main indicator of the success of the military effort in that period of time, that period of the armed conflict. There is not importance of another results different to the killing of the enemy. And because of that, dozens of farmers, traders, informal transporters, vulnerable people were part of the false positive killings, with the necessity to present results in every form possible. Many of the victims were reported as unidentified persons. Some crimes were committed by armed forces and paramilitary groups. And sometimes they used public resources to simulate false successes in the armed conflict. And also, in this context, in the macro case, we put a special attention to serious, differentiated, and disproportionate damages against groups of special protection, like indigenous peoples in several parts of the country. And considering the time, I would like to highlight another 3 macro cases. We have 11, but I only put attention in 3 of the macro cases. This is a case related to recruitment and use of girls and boys in the armed conflict. I would like to highlight that we have into attention more than 20 years of recruitment of children in the context of the armed conflict, with some prioritization in this kind of crimes, sexual violence and enforced disappearances, and homicide, torture, and inhuman, cruel, and degrading treatments to children inside the guerrilla of the FARC. And in these finally 5 minutes, I only put attention in the restorative dimension of our work in the context of the macro cases. What we are doing to transform the previous intervention of the ordinary proceedings. In this dialogic procedure, first, we open a floor for the victims to present their voice before the special jurisdiction, gathering reports from institutions and civil society. We received more than 900 of reports around the whole country, and our objective is to make visible their voices about the facts, the patterns of violence, and the harm. And this is a voice that we recognize that previously they didn't have a voice before the ordinary proceedings, and because of that, it was our starting point. Second, we recognize the legal status as victims of those who accomplish all the requirements established by law, but also, for examples, for instance, we recognize territories as a victims, for instance, in several macro cases that we are working now, or the participation of some collective groups of victims in the context of the proceedings. Third, we use this voice from the victims to put before the perpetrators in order to ask them what they are thinking about the voice of the victims. We summon the perpetrators in order to present voluntary statements regarding the reports. And in that context, we ask, we change the kind of cross-examination in the ordinary proceedings in order to understand why a person is involved in political violence, why a military personnel, after 10 years of work within the army, transform their path in a path of in a participation of killings or another crimes in the context of the macro case that I mentioned before. When was the first time that these perpetrators involved in this kind of political violence? And four, we receive the victims' perspectives, the victims' observations on these voluntary statements from the perpetrators. We ask to the victims about what was adequate in that cross-examination, what was re-victimization, what is pending in the context of the declarations. And five, after this dialogue with the victims and with the perpetrators, we organize indictments, considering the voice of the victims, considering the proof, but considering the collective harms and other kind of harms presented in the case. We have an example, for instance, in one indictment, the damage to memory and good name, the damage to the cultural integrity of indigenous peoples, the damage to the health of family members, the loss of harmony of communities and indigenous peoples, and another kind of damages. And we put this in an indictment, organizing also the patterns and policies behind crimes against humanity in the context of this analysis of macrocriminality. And sixth, we organize a public hearing between the victims and perpetrators. The picture that I used at the beginning of my presentation is the public hearing of acknowledgement of responsibility for the FARC. And this is a picture of the acknowledgement of responsibility of military personnel front to front before their victims in the first public acknowledgement in the context of extrajudicial killings. We can see here the first general recognizing their responsibility about these kind of policies behind these more than 6,000 of executions. And we organize these public hearings, and we explained that the voice of the victim was the path to acknowledgement of responsibility in the context of this restorative procedure. And after that, we organize these encounters after a separate work with victims and perpetrators, and in this context of encounter, we overcome asymmetries between victims and perpetrators. And finally, we submit a decision to the Tribunal for Peace with proposals of restorative sanctions. This is important because the kind of sanctions in the context of the special jurisdiction include the possibility of restorative sanctions to crimes against humanity, to war crimes. We are talking about no prison in this kind of international crimes. In the context of fully committed, when a perpetrator is fully committed to the whole truth and integral remedies for the victims. And we have alternative sanctions or ordinary sanctions in the context of non-acknowledgement of responsibility. In that cases, the perpetrator can be subject to until 20 years in prison in this context of non-acknowledgement of responsibility. And finally, I would like to finish my presentation saying that the major trends, the major challenges for the future are how to achieve this kind of massive victim participation in the macro cases, how to manage legitimate representation of victims in this kind of macro cases, how to present collective decision-making in a military outfit, for instance, to assign individual criminal responsibility in this context of collective violence. What are the human rights standards in terms of due process and victim participation in transitional justice? Is the same participation when we are dealing with one individual case, and what is the change when we are dealing with more than 6,000 of extrajudicial killings? How to learn from indigenous justice and collaborate with traditional authorities, and finally, how can use restorative justice to punish these kind of crimes, and use the restorative justice to be part of reincorporation into society. This is a starting point for our discussion, and thank you for your attention.
Thank you very much, Justice Parra-Vera. This confirms my impression. This is an extraordinarily complex, but also creative and transformative process. So we look forward to, I'm sure, to asking you questions. Next, so we'll have all the presentations. First, obviously, Justice Alexandra Sandoval-Mantilla will be speaking on the gender justice dimension of the transitional justice effort in Colombia. Thank you.
this is on? Yeah.
Yeah.
So good afternoon for everyone. I just want to start thanking the McGill Center for Human Rights and Legal Pluralism. Sorry, that's a difficult word for me, even in Spanish, to pronounce it. And well, thank you for the invitation. This is, for us, it's an honor to be here and to tell you and to show you the work we have been doing for the past 5 years in our country. The Judge Oscar presented the generality of what we do, but I'm going to focus on the gender approach and how this is being worked and the innovative part of what we are doing. So he did a good introduction about the armed conflict in Colombia. What I want to highlight is that we have almost 10 million persons that are living in our country. We're around 55 million persons in Colombia. So that's a huge number to think about it. If you realize it, I once thought that that means that every family in Colombia has a victim, at least. And if you see of those 10 million persons that are victims in Colombia, 52% of them are women and girls. And that means that we have a huge problem. And that in order to deal with the past, and lastly also with the present, we have to take into account what had happened to these women and girls. So we are really proud, and every time we present the peace agreement in Colombia, we say that, and it's true, that this is the first peace agreement in the world that includes a gender perspective. And since it's the first one, you will think it was easy to introduce the gender perspective in the peace agreement, but it was not. And this is because when the peace negotiations started, we did the negotiations in Havana and Cuba, none of the persons that were participating in the negotiation were women. And that has something to do with it. When there are not representation or enough representation of women where no one was thinking about it. But thankfully, in Colombia, we have a strong women's organizations. And they start making pressure to the persons that were there in the Havana saying, well, what I just told you. If 52% of the victims are women, something has to be done in this peace agreement. So on the half of the way, they accepted to create this gender subcommission to start integrating the language, but also the perspective in the agreement. And at that point, they had negotiated at least half of the agreement. And what we have to do, because at that time I worked in an NGO that tried to introduce the gender perspective in the agreement, what we started was to look at what they had already agreed and to try to think what we could do to repair those women that were victims. But not only the victims, how can we change the country to make it a more inclusive country? So at the end, what the peace agreement says is that the gender approach is a principle that has to be implemented in all the rules and proceedings that were created in the agreement, but also it established at least, it depends on who counts it. I always say it's 121, but someone says it's 100, others say there are 130 specific measures to ensure the rights of women and girls in the agreement. And to give you some examples, for example, in what we do in the Special Jurisdiction for Peace, there were some rules established that were really important. For example, that sexual violence is not possible to grant amnesties in this type of crimes. And this was really important. It seems easy to say it, but it was the first time that it was done. Also, that we needed a special group for investigating this type of crimes. That it was not enough to have a prosecution office, but that we needed some experts to do this kind of work. And the other one, that I'm really proud of it, because I'm proof of that, is that it established that the entities, the tribunal, the Truth Commission, and all the bodies that were created in the peace agreement had to have a representation of women. And I'm glad to tell you that we are 32 judges, and 53% of them, we are women. And of those 38, also 8 of them are part of ethnic groups in Colombia. 4 of them are indigenous, and 4 of them are Afro-Colombian. And this is really good for our country, because we have a history of discrimination. And this was done because it was established in the agreement, but I wanted to tell you that this was also a win of the Colombian women's organizations. So, when the special jurisdiction for peace started, we had this mandate to implement not only the gender perspective, but also the ethnic perspective and the territorial and environmental perspective. And why we do this, or why the peace agreement has this mandate. Because if you see a Colombian map and you look where the ethnic communities live, and then you look where the war was worse, and then you look, it was not in the cities, it was not in the main cities, you can see that if you don't take into account the approaches, you are not going to respond properly to the victims. So when we started, we created these permanent commissions. The Judge Xiomara is going to talk about the ethnic commission, but I'm going to focus myself on the gender commission. So what we do in the gender commission, well, basically we try to promote and to effectively implement the gender perspective in all of the proceedings that are made in the special jurisdiction for peace. We are six judges that are part of the commission, but also every department of the special jurisdiction. You saw the picture of all the chambers and everything that we have that is really complex. They have a representation there. And we started working, and of course the first question was how we define the gender approach or the gender perspective in the special jurisdiction for peace, because sometimes we talk about it, but we don't really know what we are talking. So, well, first, we see it as a methodology to acknowledge and transform inequality between genders. We know that this is bigger and it's more important, and it's not only to be applied in transitional justice. And so we know it's a methodology that can be used not only in times of war, but also in times of peace. Another point that we decided since the beginning, and this was really difficult in a point in Colombia to say it, is that when we are talking about the gender approach, we're also talking about the LGBTY community. And why it was difficult? Because when the negotiation of the agreement was made in our country, one of the main topics that was discussed was the recognition of this community as victims, and also a recognition of them as persons that were victims in the conflict, and that we had to ensure their rights also in the procedures. So the Special Jurisdiction for Peace, since the beginning, accepted that we were working not only with girls and women victims, but also with the LGBT community, and this was also something new to do. I told you, this is the first time a peace agreement that has a gender approach, and also is the first time a tribunal is trying to collect information and to show how this community was damaged and the harm they had during the conflict. The third point that we took into account when we defined the gender perspective is that the armed conflict is not the main cause of the gender violence that women, girls, and the LGBTI community suffered. These people suffer violence and discrimination in times of peace. What the conflict does is that it makes it worse. But even if we say someday in Colombia we don't have an armed conflict, these people are still going to suffer this kind of violence. So if we want to change something, we don't have only to focus on the conflict, but on the main causes that cause this kind of violence. And the fourth point that was really important for us is that to take into account that the harm that suffer women and girls and the LGBTI community during the conflict was disproportionate, and different that the others suffered. And by that recognition, it's really important not only to acknowledge the truth, but also to think about the reparations they are going to get, and also to think about the proceedings and the things we have to take into account in the hearings, in the reports, in order to guarantee them their right to justice. So what does the Gender Commission do in practice? We have a special function that is not really common for people that work in judiciary systems, is that we can make concepts for our colleagues. For example, if one of our colleagues has a case that involves the gender perspective, they don't have to be experts, but they can call the commission and tell them about the case, and we will make a concept saying to them how they can respond, how can they protect the rights of the victims, or how can they try to do the things in order to implement the gender perspective. This is not really common because sometimes, well, most of the times, the judges, well, they have autonomy. So someone that is telling them how they should do the things is not really common. We do the concepts that are not mandatory, but what we have seen in practice is that the judges use them in the cases. At this point, we have more than 40 concepts from different topics. The relation between sexual violence and the armed conflict, that is one topic that it has been discussed a lot in our country. How to prove that one specific sexual violence crime was committed in the armed conflict or relating to the armed conflict. So we gave them the tools to make the analysis. Sometimes we don't make the analysis, but at least we gave them the information that will make them take the best decision as a judge. The other function that we have as the Gender Commission is that we promote the participation of girls and women in the proceedings. And this also is not as common, but this is a special jurisdiction, this is transitional justice, is that we work with the women's and LGBTI community movement. And we go to them to not only to explain what we do, but also to coordinate and articulate how they are going to participate in the proceedings. And finally, we do all the cooperation with the other institutions of the state, because a lot of institutions are involved, and we try to promote the gender perspective in all of them. So we have had some progress, really important progress for me. For example, the rules of proceedings that we have in the Special Jurisdiction for Peace also have special articles that implement the gender approach. To give you an example, we have an article that says that not a woman, not a person that have suffered sexual violence, it's obligated to be confronted with the perpetrator if she or he doesn't want it. Also, I will say this is easy, but this is really innovative for rules of procedure. And this was one of the main discussions that we had at the beginning of the special jurisdiction. This is one of the examples of the many articles and rules with gender perspective that we introduced to these rules of proceedings. We also have the concepts that I talked about it before, more than 40 concepts that have been done for the jurisdiction. And also, we have guaranteed the participation of the women's movement, as I was telling you, but in one really important point. The way the victims participated or started participated in the special jurisdiction, as Judge Oscar explained before, was with the presentation of some reports. But these were not like the usual petition that you will present before a tribunal. This has to be collective. It was not only one victim. So you have to organize the group of victims, so they will present the reports of the cases because they were in the same territory or in the same time lab, or they had suffered something similar. And what we did at the beginning of the special jurisdiction for peace, what the Commission of Gender did was to approach these women and to teach them how to do the reports. We couldn't do the reports because after that we were going the ones to receive those reports. We were the judges. But at least explain to them how they could do it in a simple manner. So with this way, we can encourage them to participate. And I will show you after we had a really good response from the women's and LGBTY community in this matter. But also we have several challenges. Since I don't have so much time, I'm going to refer to only two of them, and it's the case of sexual violence and the topic of intersectionality. But also, all of the topics with the LGBTY community is one of our challenges because, as I was telling you before, this is the first time that a tribunal is doing this. So, for example, we don't have as much legal definitions for much of what had happened to them. So we have to create and define and try to understand to give them a good legal response. And also on the matter of restorative justice, the question is how to repair women that have suffered gender-based violence or sexual violence when this is a transitional justice system that it's at least not going to send to jail most of the perpetrators, but that these perpetrators have to acknowledge the truth and to reparate the victims. And the question is, how do you repair sexual violence? And it's a main question, but I'm not going to focus on that. So, about the sexual violence in the peace agreement. As I was telling you, a lot of what was established in the peace agreement, it's new. It seems easy, but it's new. And this is the first agreement that established sexual violence as a specific crime. And it did it to say, as I was telling you, that it's not possible to grant amnesties for this kind of violence. But also, the agreement established that women and girls were the ones that were more affected for this type of crime. So this is important because it gave a mandate to the special jurisdiction about dealing with this type of crimes. And this takes you to a debate that is currently occurring in our country, and is the necessity to open a macro case about gender-based violence, including sexual violence. Has been a demand of the Colombian women organizations and of the LGBT community organizations since the beginning of the Special Jurisdiction for Peace. It also has been a demand of the international community because it's an opportunity. This will be the first time that an international internal tribunal that is trying to investigate and sanction war crimes, it's going to see specifically these crimes individually, but not as only as a type of crimes that occur with other types of crime during an armed conflict. What is happening right now in the special jurisdiction? Judge Oscar told you that we have 10 other cases. In all of these cases, they are trying to investigate also gender-based violence. And this is important, and was important since the beginning for the Gender Commission, because we told them since the beginning that it was important to acknowledge that in all of these crimes, kidnapping, recruitment, extrajudicial killings, there were also women. And that we have to see how they had suffered this differently than the men. For example, for women that were kidnapped by FARC during years, what had happened to them, not only that they were possibly in danger of being sexual abuse or could be in that kind of situation, but they described some type of situations that had to be taken into account. For example, they described how during the kidnapping, every time they had to take a bath, they were surrounded by men that were, of course, taking care of them, guarding them, and they had to be naked in front of these men. This could be totally different, the experience can be totally different for a woman than for a man. And to acknowledge that, it's really important. So what we said in the Commission since the beginning is that every macro case has to have the lenses of their gender approach. But this is not enough. As I was telling you, the Colombian Women's Organization and the women's and the persons from the LGBTI community that were victims of sexual violence want to have a specific case. And this because this has also a symbolic meaning. This is to tell our country that during the war, not only men killed or people kidnapped, but that this happened all over the country, and that the number of victims is really, really high. I was telling you that one of the progress that we are proud in the Gender Commission is the reports that we received from the victims. And I wanted to tell you the numbers so you can imagine how difficult the situation is. So from 1977 victims reports presented before the Special Jurisdiction for Peace, we have identified at least 2,047 facts related to gender-based violence, including sexual violence committed by FARC-EP, by the guerrilla group, and 1,103 facts committed by the army in our country. So it is true, and we have it in numbers, that this happened, that it happened all over the country, and that it's necessary to investigate and to sanction those that committed these type of crimes. So, because of this, the Chamber of Acknowledgement or Recognition right now is in a phase that is prior to the prioritization of the case, is taking into account the reports that the victims presented, but also that the information that we had before from the state. And we think, or we hope, that they will open the case soon, so that we can start having what you saw in those pictures, those type of hearings, but in cases of sexual violence. about the topic of intersectionality. This is really also interesting. Remember that I told you at the beginning that most of the conflict occurred in territories where ethnic groups lived in Colombia. So this means also that a lot of the victims are not only women, but also are women that are indigenous women or Afro-Colombian women. So this meant that we have to use this concept of intersectionality that comes, it's actually a response to the white feminism. And it's a response to acknowledge that most of us, most of all women, are not only women. We're a lot of things. I'm a judge, I'm Colombian, and I'm a woman. And Xiomara could say it, she's also an Afro-Colombian woman. And that makes a difference when you have all of these coexistence factors in your life. And sometimes those coexistence factors can be based for violence and discrimination. What is really interesting, what happened in Colombia, is that we took that concept of intersectionality that was created also in the north part of the world, and we made our own concept, and it was included in the peace agreement. And it's called, and this is a little translation from Spanish, is the Women and Family and Generation approach. In the ethnic chapter that Xiomara is going to explain in a wider manner after my presentation, the indigenous and the Afro-Colombian women said, okay, it's important to have the gender approach, but you have to take into account that that approach has to be different for us. Because if you don't make it different, you are not accepting that we have different factors of discrimination and violence. And I wanted to give you, I gave you the numbers of victims in Colombia. I wanted to show you how bad it was for the ethnic groups in Colombia. Of the 10 million, almost 10 million victims in Colombia, 10% of them are Afro-Colombians, and 5% of them are indigenous people. And this is really big because 14% of our population is Afro-Colombian and 4% of our population is indigenous. So this almost shows that most of them were victims in the conflict. And then when we think that half of them are women, then you see how disproportionate this was in the conflict. So what we have done to implement this women and family and generation approach. First, we started talking to the women, to the Afro-Colombian and to the indigenous women. We thought that that was the most important thing to do in order to understand the approach. The approach, this kind of approach, tells us that if we don't hear their voice, we're not going to understand why they're talking about not only women, but also about family and regeneration. And this has to do with a lot of the way they think. For example, indigenous women, and I heard it when you did the presentation, in Colombia have the same idea of the relation with the territory. So when they were victimized, they were not only the victims, their community was also a victim, but also the territory. And to take that into account in our proceedings is necessary in order to guarantee this intersectionality, or the women, family, or generation approach that was established in the peace agreement. So what we did is we did a lot of proceedings. We established a way to communicate to them and to relate to them in order to make them participate in the proceedings in the jurisdiction. And also we have had some concepts that we had worked together with the Ethnic Commission, not only from the gender perspective, but also with the Ethnic Commission in special cases. and I'm going to finish with this, one of the concepts that was really interesting was about a girl from an indigenous group in Colombia that is called Waju, that was victim of sexual violence by FARC. And we had to know how to communicate the decisions that we were taking to this girl. For me, as a feminist, the answer was contact her, because we have to establish, or at least to guarantee that she participates in the process. That was my first approach as a feminist. But then the community and the women of the community explained to us that if we did that, we will re-victimize her. Because in her community, what you have to do first is to approach the authorities of the community. And this community in particular has one person that is in charge to receive all the news of the community. So we have to first talk to this person and then talk to the girl, because I was not going to accept that we didn't talk to the girl. We had to do both. But they teach us how to do it. And this was what actually we did in the special jurisdiction. But it shows to you that when we were talking about gender approach, and especially the ethnic approach, what is most important to do is to talk with the victims first. They are the ones that are going to guide you how to do the proceedings and to not re-victimize them in this type of justice that it's really difficult to manage, because we are talking about really several crimes, and it's really important that we do the proceedings in a way that really respond to the demand of justice that women, girls, and the LGBTY community has in this peace agreement. So I will finish with this. Thank you very much.
Thank you. Okay, good afternoon. Okay. I want to start saying thank you for this invitation, and thanks for all of you for being here. I think that Alexandra and Oscar said everything, but I'm trying to say something about the ethnically and racially different approach in the special jurisdiction for peace. As you know, and Oscar said, more than 5 decades of non-international armed conflict, but Alexandra said something that is important to remind. The conflict in Colombia is continuing. We are trying to fit with that, but and we are trying to make another peace agreement in this moment with another group, that ALN, and we are trying to resolve the problems, but the ethnic communities are still suffering the conflict. The construction of a stable and lasting peace in Colombia is only possible with the presence and the participation of the ethnic peoples, who account of the diversity and the multiculturalism of the country. Therefore, for the special jurisdiction for peace to achieve the highest justice and accountability for violation of human rights and the infraction of the international criminal law that occur through the conflict is must respect in principle like the self-determination, autonomy, and the self-government participation, consultation, and prior free and informed consent of ethnic peoples, among others. As a jurisdiction, we are mindful of the great historical work we are carrying out. We know that to advance in the construction of peace and achieve the real reconciliation in the country is necessary to a correct administration of justice where practices implemented by ethnic communities of the legal system. We know we need to coordinate and articulate through the intercultural dialogue. I want to make a contextualization of the ethnic charter in the framework of the final peace agreement signed by the Colombian national government and the guerrillas of the FARC-EP, like Revolutionary Armed Forces of Colombia. The armed conflict has, like Alexandra says, we know, was disproportionately affects the rights of the ethnic communities. And they have genuine and legitimate interest in participating in the different mechanisms of transitional justice created to satisfy the rights of the victims. For that reason, the construction of the peace agreement without the presence of the ethnic communities was not something possible. But I think that was the same like the women's, but the difference that I think that the gender approaching was like in the whole of the peace agreement. But I have to say that the ethnic communities, we arrived at the last of the peace agreement. I think that we have to say that because that's true. And however, we have to take into account that the ethnic chapter was possible because all the ethnic people also, and the ethnic authorities and the ethnic organizations was trying to say what happened here in this peace agreement with the ethnic communities. We need to be here, and we need to be to have proceedings, and we have to have all different because the conflict was affected in disproportionate funds. So, however, after 5 years of negotiation in La Habana, Cuba, the resistance and the resilience of the ethnic communities opened the door to them to create and include the ethnic charters. Due to the ethnic communities and the authorities create the Ethnic and Racial Commission for Peace and Defend the Territorial Rights, whose purpose is to safeguard the territorial and collective rights of the ethnic population in the process of negotiation and implementing the peace agreement. The ethnic charter begins with the recognition of the national government and the guerrillas and the guerrillas of the FARC-EP that the ethnic community have contributed to the construction of the stable and lasting peace as well as the economic and social development of the country. In addition of that, the charter states how, as the result of decolonialism and enslavement and structural racism, and ethnic communities have facing discrimination for displacement among other crimes. The ethnic charter also underscores how the international armed conflict has seriously impacted the ethnic communities and how particular measures need to be implemented to guarantee his community rights. To continue with this intervention, I want to show how in Colombia, even we have a multicultural country, and we have in the Constitution the indigenous jurisdiction has a recognition as a part of the judicial process and the judicial system, such as the Afro-Colombian justice emerged because the consolidation, I think, of our Constitution and the international human rights law and the rule of law which has been the product of the different struggles for the reivindication and the rise of ethnic communities in general. So we have the possibility to have authorities like indigenous people, but we have also Afro-Colombian people, and we also have the opportunity to talk with the room. We have room communities, I think we recognize like gypsy communities, but we also have those communities in Colombia. So the implementation of the ethnically and racially approach within the Special Jurisdiction for Peace have the necessity to create a commission, like a gender commission. So we have Ethnic Racial Commission. Since the inception, has been an institution aware of the historical work that is carried out in the construction of peace. To this extent, it has been respectful in imparting a correct administration of justice within the framework of the final peace agreement, and in a different national international standards, which necessarily implies the incorporation of the ethnic charter discussion in the work of the Special Jurisdiction for Peace. This has been possible due with we have to understanding of the right of the self-determination of autonomy, which includes the duty to recognize and respect traditional authorities, but also the implementation of prior consultation to understand the ethnic and racial approach in restorative justice. So, in this 5 years of the implementation of the Special Jurisdiction for Peace, has fully to fulfill this mandate by gathering information, conducting hearings, making judicial decisions, and accredit victims. So in 2021, I think yes, we published a protocol with relationship between the Special Jurisdiction of Peace and Black, Afro-Colombian, and racial and Palenquero communities. The protocol, for example, specifies how the Special Jurisdiction for Peace has to need to coordinate and dialogue with the authorities from communities, councils, and other organizations to guarantee the full participation of the victim. We also have the same, not the same, but we also have a protocol with the indigenous people, and we also have a protocol with room communities or gypsy communities. That in order to guarantee the participation of the ethnic people at the Special Jurisdiction for Peace. This commission that in that moment I'm coordinating, the Ethnic Commission is a permanently institution that has judges belonging the ethnic communities. Also, we have the director, for example, of the Investigation of and Prosecuted Unit, we call Unidad de Investigación y Acusación. We have also the executive secretary in the permanent in the commission. We also have the president of the Special Jurisdiction of Peace in this commission, and we have 2 judges that are not ethnic that also belong to the commission. We have a lot of functions, but I think we are in shape for the principles functions that are, for example, we promote the adequate incorporation of the ethnically and racially differentiated approach and the effectiveness of the interjurisdictional coordination between the Special Jurisdiction of Peace and the different ethnic justice systems. We also formulate and define and issue guideline concepts and programs to link the effective incorporation of the ethnic approach as a transversal component to the implementation and the operation of all procedures in the Special Jurisdiction for Peace. We also do recommendations that guide the exercise of the chambers and the sections on the cases or on the micro cases related to ethnic communities. We support the formulation and application to the ethnically and differently approach, which make it possible to determine condition and vulnerability of their differential impact on their peoples among. Now I will take a few minutes to talk about the macro case 09. Yes, that's crimes against ethnic communities and their territories. Why I want to talk about? Because I think it's the first time that someone will be investigated for the crimes against ethnic communities in Colombia about the armed conflict. I think that's really important for us because the systematic and differentiated harm suffered by ethnic communities in the context of the non-international armed conflicts. I think because the communities and the ethnic authorities has a legal subject of rights. The ethnic communities and their interdependent relationship with their territory has a legal subject. I think in this micro case we are trying to investigate what happened with the ethnic communities, but also we try to investigate what happened with the territories for these communities. This last aspect is fundamental within the micro case due to the weight of understanding the territory of ethnic communities that I said, but for them, because we need to understand that for them the territory is seen as a source of life, existing and identified. It's understood as a living subject with which there is an ancestral relationship. Therefore, when the armed conflict began to affect their ethnic territories, ethnic communities felt that mere existence or future generation was a risk. Also, the criminal macro case on the war impact on the ethnic communities is of a national scale. But the special jurisdiction of peace and the chamber of the recognition of the truth we have a methodology that we call like illustrative territories, because we need to know that we are a temporally special jurisdiction for peace. We have 10 years, I think 10 years more, no more than. So we are going to be a concentration in an illustrative territory. So we are going to investigate what happened with communities that are located in Sierra Nevada de Santa Marta and surrounding areas, communities like are located in the Pacific area, that Buenaventura, Dagua, Timbiquí, López de Micay, and Guap is a specific territories. Amazonia, you know, Amazonia is I think the biggest one. Orinoquia, and what happened in Chocó, where is from Judy. Why we are trying to locate it in these communities? Because the disproportionality armed conflict suffered the ethnic communities in these territories. So, and we need to know that we received like more than 545% of reports presented by ethnic and human rights organizations that they identified how the conflict affect the community of the people that are living in those territories. Also, we are going to investigate crimes, but we are trying to identify, for example, homicides, massacres, forced displacements, forced disappearance, attacks against civilians, cultural property and places of worship, destruction of the territory in the inescapable relationship with the existence of the ethnic communities, and other behaviors associated with the pattern of the cases. And those crimes are the ones we are going, I think that we are going to try to investigate in this macro case. Okay, now I have like a final thought that I want to present. I think that the implementation of the ethnic racial approach in the special jurisdiction for peace is today an undeniable reality. In this regard, I think the notion of the preferential and the prevalent jurisdiction of the special jurisdiction for peace serves as a safeguard to guarantee its prerogative as a justice component of the system, which has the demanding task of imparting justice with respect to the conduct communities in the framework of the armed conflicts between the FARC-EP and the Colombian state, always basis of the respect for the ethnic people. In an armed conflict as complex as the Colombian one, within the framework in which violation of human rights and international humanitarian law were communicated. I think the necessity of collaboration between different jurisdictions is understandable and is a necessity of the Special Jurisdiction for Peace. In that order, the transitional justice and peaceful coexistence are achieved as the goals of this state. The interjurisdictional collaboration between the Special Jurisdiction for Peace and the ethnic justice require a joint effort and continuous intercultural and institutional dialogue that allows guarantee the effective participation of the victim of the different ethnic communities. In this regard, what is essential is that both the Special Jurisdiction for Peace and the ethnic justice need to continue to act jointly in search of the most appropriate interaction procedures in order to respond to demand of the current transitional process. The Special Jurisdiction for Peace has multiple challenges. I think in the implementation of the ethnic and racial approach, we are doing a lot, but we know that we need to do more. However, as a judge, we will not give up on the search for justice and peace for the ethnic peoples in Colombia. We will continue advising with a firm step, even they treating us, trying to hinder our work. I think ethnic peoples in Colombia have suffered greatly from the armed conflict and the structural racism. The ethnic people demand truth, demand justice, reparation, and I think as a judge, we cannot be inferior to our mandate. Finally, it should be noted that putting the rights of the victim of the center of a peace negotiation, I think, is a novel, but it's a challenge too. Moreover, the implementation of an ethnically differentiated approach is a guiding principle to guarantee victims' rights and the taking into consideration of their race, the ethnicity, the cultural difference, and worldwide is a unique feature of the Colombian transitional justice process. Both of these approaches can set an important precedent for the participation of the ethnic people in a future process of the transitional justice. Consequently, this model of transitional justice can be a source of inspiration, I think, for other similar processes in Colombia and other transitional justice around the world. Thank you.
Yeah, on these concluding words, I mean, I'm reminded that, one striking aspect of transitional justice is how every new wave has tended to learn from the previous ones. And so I think the paradigm keeps getting better, but of course, there's a lot of challenges. I mean, a few years ago it was South Africa, and there's been lots of discussion in Bosnia as well, and I think now Colombia. All right, well, I think we have about 25 minutes left, and I'm sure many of you are eager to ask questions. We have 2 microphones on each side, so I think the best thing is if you go to the microphones. That's how we do it traditionally, to make sure that everyone does hear your questions. So please go, and if you can just introduce yourself, go ahead.
Hello there, my name is Tara. First of all, thank you so much for coming to speak to us at the law faculty today. I know we all really appreciate it. My question is in reference to the macro case number 7 that was discussed about the recruitment of children into the fighting forces. I was wondering if there's any mechanism being developed in the court to deal with fighters who were coerced potentially as children into participating in some of these crimes.
Maybe we'll take just a couple of more questions. Yeah, go ahead. Sorry. There you.
Thank you, and thank you for your presentation. I'm Colombian, and I'm feeling very proud that all the achievements that you have said, and it's really lovable to hear your accent here, because I'm full of accents from different parts of the world, so it's good to feel at home. So my question is, you mentioned that there has been in the process different perspectives, like the ethnic perspective, gender perspective, but also unions are workers, are parts of the, not directly related to the conflict, but are key subjects of, or they play a role really interesting in the community now that we are building a new social dialogue. So my question will be, now that there is a new process or a new negotiation with the ELN group, do you think that in this case would be something different to try to involve unions or associations of employers in the negotiations? I know that's not your field, but perhaps we can have some insights from that perspective. Thank you so much.
And maybe we'll take a third question to get us started.
Thank you again for coming. It was a really wonderful talk. I had a question related to apologies and the amnesty procedure. I think one of the difficulties many transitional justice procedures run into is evaluating sincerity, because it's kind of a very internal sort of affair. I was wondering how you conceived of that challenge and, in a sense, how you would respond to it.
Great. Why don't we start with these three questions, and then we'll take a second round. Who wants to start?
Oh, thank you very much for these questions. I would like to begin with some information about macro case number 7, about recruitment of children. First, this is a very complex case because a lot of victims of recruitment in Colombia are people who in the past were part of the FARC, but they get rid of the FARC or escape from the guerrilla, and they are anonymously in their towns with a lot of people that they don't know that they were part of the FARC. And because of that, for a victim to say, I was a member of the FARC, recruited with any consent or with a lot of coercion to do that, is very difficult. And because of that, one of the most difficult part of the work is to construct trust with the victims. And this construction of trust is a very long path. We have to work in a lot of parts of the country to open several scenarios for victims to come anonymously. A lot of people are with a lot of fear with the previous captors, with the previous commanders at the FARC. But we have a lot of several steps in the context of the proceedings that we are working with them. And I would like to highlight the victims of sexual violence in the context of recruitment. We have taken into account even reproductive violence with the use of forced abortion and forced contraception with a lot of girls and young women inside the FARC. And we have received a lot of reports, and a lot of them are with no publicity, is a material, internal material for the special jurisdiction. we began hearings about the cross-examination, the voluntary statements from the perpetrators. We have had more than around 50 or 60 voluntary statements from the FARC, from the guerrilla of the FARC. A lot of people inside the FARC, from the FARC, denies, or in the context of this cross-examination, denies some part of the patterns. We are contrasting, or we have had several judicial activity to analyze the statements from the FARC, and we have a lot of judicial activity to organize the information from the victims. At this point, the macro case is advancing, and recently we did the first indictment focused in a territorial case in Cauca, with not with the most responsibilities in the context of the secretariat of the FARC, but the most responsible in the context of particular units from the FARC in the Cauca. And we began with this indictment, and we use some examples even of executions of children inside the FARC. We describe some cases in this first indictment. And because of that, we are at the beginning of the accountability phase of the proceedings, and we expect to develop more of this, of the macro case for the future. The second.
Well, about the question, if it's necessary to apologize in order to get to grant an amnesty, or in the macro cases. Well, I think since we in Colombia before we had another process of transitional justice, one of the lections that we learned in that process is that apologizing is a personal process. And to accept that apologize is also a personal process. And to measure if that apologize comes from the heart, it comes from a good intention, it's really subjective. So because of that, and because we also knew about other experience in the world, in our process, it is not mandatory or necessary to apologize. For an amnesty, to grant an amnesty, we see like some requirements that the person was from FARC, that the conduct was related to the conflict, and that are actions that can be, that you can grant an amnesty, that are not war crimes or crimes against humanity, that are facts or that were conducted according to IHL, basically. And so we don't ask them to apologize. In the macro cases, in order to get the benefits, what we require is that, well, they accept the responsibility, they tell the truth, and they are willing to reparate the victims. What has had happen in the hearings is that sometimes the perpetrators want to apologize and to ask for pardon, but they do it on a personal way. We don't require them to do that. And we know it's difficult to measure it. We had some complaints from victims in Colombia that when they had been in the hearings, they say, I don't feel it real. I think they are doing this because they will get benefits of this. And what we can say to them is we cannot measure that. We cannot go inside the heart of these people and tell if it's true or not. But what we can do is we can measure if they are telling the truth and how account they are accepting the responsibility. So we try not to do like this moral judgment in our proceedings.
I just want to add something, is that I think the Truth Commission had a lot of meetings with the perpetrators and victims, and they apologized, but I think that Alexandra said is a challenge. I think it's not just apologize, because that I know for the indigenous people, for example, in Colombia, they think that people, because they say it always in hearings, are people that in Spanish they say desarmonizadas. I think I was trying to say, Yuri, how to say that? He said of the grown path of life. And the indigenous people think, and Afro-Colombians think that they need to find people to find peace for themselves, and then they can say apologize. So I think it's a procedure and it's a challenge to apologize.
And to the other question about unions and the Association of Employers, I would like to highlight two macro cases that we are working on the topic. One of the macro cases is a macro case regarding the political violence against the political party Unión Patriótica, the Patriotic Union in Colombia. We have one macro case and a lot of members of unions and associates of workers in Colombia were part of the Patriotic Union. And also in macro case number 8 is a macro case regarding political violence in the context of the armed conflict associated to the links between state officials, the army and the police, and paramilitary groups. And one of the most important victims in the context of this macro case are unions. And we have been analyzing a pattern of violence against unions as a part of the strategies of the paramilitary groups to take control of several territories around the country. And I think that for future peace negotiations, this will be a very important part for the negotiations.
Wonderful. So we have quite a few questions. We'll take a last round. I have 5 questions, I think. So please go ahead.
All right. Thank you so much for coming. This is very exciting. I lived in FARC territory, but in Ecuador. So in the Amazon region, on the Ecuadorian side, and that's why I wanted to go into law. So your work is very, very important. One of the questions I had when I was speaking to victims when I lived, this was in 2016, there was a blurry line between who was a victim and who was a perpetrator. And I guess I'm wondering how that is balanced in your judgments. And then another follow-up question to that is about the indigenous communities who were victims but also forced perpetrators in some ways. And my question there is, what is the state doing concretely, other than reparations in terms of apologies? Are there monetary kinds of responses to kind of preserve the cultural losses that occurred? Thank you.
Go ahead.
Thank you. My name is Maria Rodriguez, and I'm an alumni from McGill Law. So I'm also Colombian, so I'm very grateful that this event is happening here. Very happy for McGill. I have 2 questions. One is, what do you think is the perceived legitimacy of the HEP in Colombia, in the society, given that there's a great fraction of Colombian society that has resistance to the work of the HEP? And kind of related to that, what do you think are things the HEP can do to kind of dispel some of the myths or misinformation regarding the work of the HEP and regarding specifically that they're giving amnesty to all the guerrilla members, which is not true. And then the second question relates to the gender perspective or approach that Justice Alexandra was explaining. And I'm wondering, since this is very innovative and generally sexual violence or gender-based violence hasn't been recognized independently, how are you working to kind of inform the victims that this is a specific kind of crime and that they can self-recognize as victims of this kind of crimes, including, for example, reproductive violence, which is something that is very, very innovative, but that is not necessarily perceived as something that was a crime and something for which people can be recognized as victims. Thank you.
Go ahead, go ahead.
Well, thank you so much. My name is Laura. I'm also from Colombia, and I'm very happy to have you here. My first question is, how do you manage with the disagreements that you would have between the victims and NGOs and civil society with the decisions that you made? Not the decisions that you take that are subject to an appeal, but maybe some internal decisions regarding participations, events, and other kind of decisions, because I understand that in Colombia, thanks to the participation of civil society, we have this ethnic perspective, gender perspective, but I also know that victims and civil society would never feel that their opinions are taken into account and there's enough participation, there's enough truth, there's enough reparation. So I wonder, how do you manage with those critiques? And my second question is, how do you manage with the interaction between those territorial cases and those cases that are more focused on crime? Because I imagine there might be some discussions or I don't know, disagreements between those. So yeah, that would be my questions. Thank you.
Hello, my name is Alexandra. I'm also from Colombia, and I am extremely happy to have you guys here because I'm passionate about constitutional justice and international criminal law. So I have two questions. The first one bounces off Maria's question, but it's a more personal question. When you're talking to Colombians, I mean, I have family members who are very much against the use of restorative justice approaches, i.e. no prison, to deal with these crimes. I'm wondering how you have these personal discussions with people who tell you, why are people not going to prison for these crimes? But yeah, again, from a personal perspective, if you can speak to that. And secondly, I'm very interested in how, in your interactions, if any, with the International Criminal Court, I understand that the ICC was very hesitant at the beginning of the peace talks to accept sanctions that didn't include prison sentences. But they wavered and they're like, yeah, we're gonna support this agreement from what I understand later on. I'm wondering how those interactions continue and if you know of any discussions about this approach being used in the context of other conflicts that are also under the jurisdiction of the Rome Statute. Thank you.
All right, one last question.
Okay. Yeah, good afternoon. Well, my name is Juan Pablo. I'm from Colombia too. Well, my concern is more about the diaspora, the Colombian diaspora. I know that we don't you don't talk about the diaspora, but as maybe we know, we're more than 5 or 6 million Colombians. The migrations start since the conflict, the inter-conflict. We don't know. Nobody knows how many Colombians there are outside the country, and I will say, I don't know, mostly of the Colombians outside, they're victims, like people from the Unión Patriótica, or people they were social leaders, and how Alexandra say, I guess, 10 million of victims there in Colombia. Probably all of Colombia, we have families, or we are victims of the conflict inter. So my question is how they have could help or listen to the victims that they're outside the country, outside Colombia, and how they could be repair. Okay, thank you.
Can you give us 1 minute to decide who is going to answer what?
We don't have a whole lot of time left.
No,
so.
I know. O sea, si quieres tú toca la legitimidad.
Quiero hablar con cualquier cosa de los perpetradores y las víctimas y cómo lo hacemos desde los pueblos técnicos.
Acá, esta. Entonces, esta Xiomara. La de legitimidad la hace Oscar. ¿Sí?
Gender, Alex.
You should answer the questions.
Participación.
10 points.
Y yo hago esta, la de la ICC.
Y yo tomo la de la participación de víctimas y tú tomas otra de los casos territoriales.
Sí, haz la de tu. La primera.
It's like a real deliberation between judges. That's what it looks like. Rapid judgment. ¿Quién empieza?
Okay.
There's a lot of questions. That's good. I think we are trying to answer all the questions, but that we have a lot of challenge in the implementation of the special jurisdiction piece. I think Oscar is going to talk about, for example, the legitimation that we have in the country. And I'm going to talk about, for example, the question about the perpetrators and how they do as a victims. And I'm going to make an example with the ethnic communities. In the amnesty chamber, we have perpetrators that are, for example, indigenous. And when we identified that we have perpetrators or we have victims that are part of the ethnic communities, we need to identify what communities. For example, it's indigenous, but you know that in Colombia we have indigenous that form different called pueblos. So we need to identify the authority of that indigenous community, and we need to start a dialogue. We call intercultural and interjurisdictional dialogue because they are judges of the indigenous jurisdictions. So we talk, for example, that they know about the case. I think that the first is to take us a dialogue about the case, what happened. Some of the case, for example, they know what happened, and we say, so please give us your version about that, what happened. Sometimes they didn't know, and they just said, we didn't know that our people or this person as part of the guerrillas. We didn't know, so a special jurisdiction of peace made the thing that you need to do. So we are not going to participate because we didn't know that. But in some cases, they say, we know, and please give us the opportunity to make sanctions. So, and we try to, so we say, okay, we have the jurisdiction in this case, and so we need to dialogue about that, and we need to know what kind of sanctions we are going to make. We listened, and if we listen that maybe the sanction is not satisfied, for example, the victims, so we said, okay, we need to make another